Any argument you wish to make or no?
Yes, let me turn my ears back on. I apologize, Judge. Give me 1 second. The state has failed to prove Mr. Ferlazzo is charged with first-degree murder. The elements are that it was he, that he caused the death of Emily Ferlazzo, that the killing was unlawful, that it was willful, premeditated, and deliberate. In this case, we heard testimony by Mr. Ferlazzo in his interview with the police that that he was overcome by rage. Oh, he was hot, he lost focus, blurry, a wave came over him. These are indications of passion or provocation. Therefore, I think that there is sufficient evidence that's already been admitted to the court that Mr. Ferlazzo was overcome by passion or provocation. That would make this not a first-degree murder case. And the state has failed, because it's their burden once there's testimony of passion or provocation, to prove beyond a reasonable doubt the absence of passion or provocation. There are, according to according to Belaski, 4 things to establish provocation. Adequate provocation, I believe, has been shown. Inadequate time to regain self-control or cool off. I anticipate the state's argument is that Mr. Ferlazzo said that he waited 5 to 10 minutes after he was attacked by Emily before he shot her. There's no testimony that that was enough time to cool off. No testimony whatsoever. The third is that there was actual provocation, and he's testified to that. And that the fourth is that there was an actual failure to cool off.
Well, isn't it the jury's determination of whether the provocation was so great as to create heat of passion that would not justify but reduce the killing from, and usually, by the way, the instruction given is usually for second-degree murder, because the case law is pretty clear that if you find premeditation and deliberation, you necessarily are not finding great. So I'm sure that's a discussion we're going to have later on when we deal with the jury instruction.
I'm prepared to address that, Judge. In State v. Yo, which was charged as a first-degree murder case,
right.
The instructions included not only second-degree murder, but voluntary manslaughter.
That's right.
And so it's not, Belaski was a second-degree murder case.
No, I'm not suggesting you may not have a voluntary manslaughter charge here. And the instruction you're wanting for the second-degree murder, I think case law may suggest that that really is a second-degree murder charge, not a first-degree, because there's an, I think it was defense lawyer who properly said that there's an inverse relationship between premeditation and deliberation and great provocation and sudden passion. But in any event, that will
In any event, Judge, my motion for judgment of acquittal is based on the fact that there was testimony by Mr. Ferlazzo in the admitted state's exhibit of his videotaped interview with the police, that he was under great passion and provocation, and there was no testimony introduced to rebut that in any way, much less beyond a reasonable doubt. That's my motion for judgment of acquittal.
So it's largely on the premeditation / deliberation pieces as compared with great provocation. And is that?
That's right.
Ms. George, did you want to respond?
Just briefly, Judge, I think that the state's perspective of the evidence is that there was no provocation. By Mr. Ferlazzo's own words, there was no, certainly not adequate provocation. There was, by his own words, more than adequate time to cool off. He first said 10 to 15 minutes, but even giving him the benefit of the doubt, 5 to 10 minutes is more than enough time from the state's perspective, at least for the jury to find that there was adequate time for him to cool off. There was no actual provocation. In his statement, he multiple times says that he was sitting there and she was trying to unfurl his piece, and that he was listening to the rain, and then he decided enough is enough. And not only got up and immediately just killed her, he got up from the couch, he walked over to the closet, he got his gun out, he grabbed a throw pillow, he jumped on the bed, he put the throw pillow over her face after she said, "Are you fucking kidding me?" And then he not only shot her once, but he shot her twice. I think from the state's perspective, those are all really clear evidence that this was not provoked, and that he had time to cool off, and he made a very clear decision, and in his own words said that it was the worst decision, but that he made a decision to stop her.
Okay. Thank you. The court will deny the motion. As parties know, this is on Rule 29, you take the evidence in the case in most favorable to the state. You don't consider modifying evidence at that time. In terms of just because voluntariness of this confession has been assessed, neither party is arguing that for purposes of this motion, but I will note for the record that the statement clearly Mr. Ferlazzo immediately says he wishes to talk to Detective Voris after Detective Voris and I've seen it done very differently, very carefully goes over his Miranda rights with him. Frankly, the court was impressed with the time he took to do that, and Mr. Ferlazzo making it very clear, he said, "I want to talk to you, let's not beat around the bush." So from a voluntariness, I think again, I just want to put that out, that certainly there's been sufficient evidence shown from which a jury could find beyond a reasonable doubt that the confession is voluntary. Because I think I have to address that since both parties discussed the statements that Mr. Ferlazzo made to Detective Voris. And then, of course, he admits we have to prove in a first-degree murder that it was Mr. Ferlazzo who caused the death of Emily Ferlazzo. That's not disputed. He shot her twice in the head, that it was unlawful. Shooting someone twice in the head while they're lying down would be unlawful. That it was willful, that there was intent to do it. He stated he had had enough. And he shot her. Then the question is premeditation and deliberation, which is the focus of a first degree versus a second degree and or manslaughter instruction. And for premeditation and deliberation, they're independent concepts, but obviously integrated. Deliberate is the ability to think and process and something, and premeditation is to have a plan beforehand. That's very simplistically said, but that's the interaction between the two. Neither can be, that deliberation and premeditation can occur over the course of months or can occur over the course of seconds, at least as the Supreme Court has thus far noted and as restated in many courts throughout the country. And so in this case, the evidence of premeditation deliberation is Mr. Ferlazzo's own words, that he had had enough, that he felt Emily was going to ruin his life, and he didn't think it was going to stop. We don't know exactly what she was saying while she was lying in bed, but his words were she had stopped fighting with me, was lying in bed, and when I determined enough is enough, I went to the closet, retrieved my Glock. Certainly, that can be a plan to get that can be deliberation. How am I going to do it? And he gets his Glock. Apparently, he gets a red pillow that may have been on the couch. Another red pillow was there. Goes over to her, puts the pillow over her face, And after she says something to the effect, "You've got to be fucking kidding me," he shoots her twice in the head. That is a plan. That is deliberation, or at least it could be thought to be. Obviously, there are defenses to that, Ms. Jantz, but as you know, that's for a jury to decide whether either the event occurred too quickly to reduce it potentially to second degree, or there was such great provocation for a jury to think such provocation was justified to the extent of reducing the charge either from first or second degree to involuntary manslaughter. But that's a jury determination. Certainly there's significant evidence from which to find that there was premeditation and deliberation. What no one has discussed yet is the very deliberate efforts he made very soon after the death of Emily to cover up what had occurred. But it could be argued, and I won't go through all of that because I'll leave that to argument later on, but a systematic effort to cover up the death once it occurred. Again, the state and defense may have very different theories as to why that was done, what was going through his mind, but for purposes of a Rule 29 motion, there is sufficient evidence from which, again, a jury could find that those steps are further support premeditated and deliberate conduct, and certainly intent on the part of or willfulness on the part of Mr. Ferlazzo, another element of first-degree murder. So for those reasons, we will deny the state's motion for a judgment of acquittal.
I understand the court's ruling and reasoning. I do object to the court's conclusion and ruling, and also note that there has been no testimony concerning a motive for any post-mortem injuries, none whatsoever. And so attributing those injuries to a state of mind is not supported by the record.
Well, he did say he was going to take the body and place it, bury it in the woods, I assume, and one could infer that it's easier to bury if they're separate parts.
My understanding is that he actually tells the police that he cut her up so it was easier to carry her.
Yeah.
Neither of those statements indicate the reason behind the dismemberment. They are, if so.
I hear your argument, and I
understand.
appreciate your effort.
Thank you.
I just think the inference can be drawn that it was done for the purpose of burying the body, and again, I won't go into other things that may support that, because I think that's really better left for argument of the parties.
And for the jury to determine.
That's what I'm saying.
Yeah.
I'm trying to keep this fairly minimal but sufficient so as not to suggest any argument to the state, and certainly to more so to protect the defense from any argument I might introduce to the state. So with that, are we ready to proceed? Is the defense planning on having a case today?
Yes, thank you, Judge. Is the court going to ask Mr. Ferlazzo if he intends to testify?
Yeah. Mr. Ferlazzo, what choice have you made in that regard? You understand it's completely your choice, obviously done with advice of counsel. You have an absolute right not to testify if you don't want to, and the court, if requested, would instruct a jury. It could not use that against you in any way. You also have the absolute right to testify if that's your choice.
Yes, I do want to testify.
Okay. Then are we ready to bring the jury in?
Yes.
Be seated, everyone. All members of the jury are present. The state has rested. Does the defense wish to present a case, Ms. Jan?
Yes, thank you. We call Joseph Ferlazzo.
Okay.